Maxims, the light of liberty's lamp. Maxims are brief statements of self evident truth. Maxims of common law explain what's fair and right, and therefore just. Maxims are self evident truth that control our courts, our legislators, and every consideration of mankind that seeks what's fair and best for all. Courts that do not honor or consider these maxims are not just. Indeed, whether and to what extent these common law maxims are honored by public leaders is how we test the way they administer the law to govern us. We, the people, are protected by the fundamental principles of justice and fair dealing set forth in these simple statements that every school child should be taught to practice for the sake of peace. Common law is built on these truths that promote the spirit and practice of fair dealings and the unbiased administration of justice. Without the legal enforcement of these truths, there can be no justice or right dealing between us. Of hope of getting our courts to do what's right by enforcing our contracts or making those who injure us pay damages. Our courts are established primarily to enforce these principles of common law. It is the common law that's common to us all. This is the law that never changes and never should be changed by legislation or the arbitrary rule of tyrants motivated by what's good for the interest of the favored few. This is the law that's all for one and one for all, the American way. The common law expressed by these maxims is for the common good. It is, after all, the common good that is the heartbeat of our American heritage. The simple saying of common law maxims evolved over many centuries as man and woman of good will struggled against the hateful tyranny of monarchies and pirates to establish governments dedicated to protect them from the abuse of those who would use the law to their own private ends. With the advent of printing presses, people were better able to communicate across political boundaries, and there began to develop an increasingly general awareness that government had duties to the governed. Interest of individuals needed to be protected. Partially toward persons with power needed to be removed. Law to protect the common welfare needed to be established, not only in the form of philosophies, but in the very office of government, where the force of military might was seated. Gradually, over a period of many centuries and at the expense of many lives and private fortunes, government's power was required to submit to the common law of the people, i.e., the people's law. This book is about that law, simple law, self-evident law, principles we all should embrace and teach our children. For example, one maximum states, a thing similar is not exactly the same. Who could disagree? It's self-evident, as are all maxims. Another saying, water does not run uphill of its own accord, nor should courts believe otherwise. These statements set essential limits on truth and are essential to the fair and efficient administration of justice according to the common law of mankind. No right-thinking person can disagree with a maximum. Every court is bound by the common law, rules of equity established by the never-changing maxims. Maxims are among the self-evident truths Thomas Jefferson mentioned in our Declaration of Independence. Maxims are the light of liberty's lamp. Maxims test those who judge and put an absolute limit on those who rule. If everyone knew the maxims of common law, our world would be a far better place. Maxims are our common law heritage. Their truths bind us together as a people. Here the hope of happiness for future generations will survive. For here are bedrock truths upon which we can all agree and by which we can secure for ourselves and our posterity the blessings of liberty and justice for all. Use these maxims to get your way in court and to command your legislator and other officers of government to do what's right. Maxims are truth on which justice must forever stand to lift her precious lamp. Let their light shine. Primary principles of common law: liberty to all, but preference to none. This maximum explains that liberty belongs to each of us equally. As stated in our Declaration of Independence, we each have a God-given right to life, liberty, and the pursuit of happiness, but none has more of these rights than any other. God gives to each by the same measure. There is no preference to any. This being so, our courts are obligated to protect our liberties accordingly. Each of us is entitled to equal treatment under the law. None is entitled to any privilege denied to others. Absolutely none. This maximum is the soul of our American legal heritage, for it was in America the concept was first given its full recognition. None has a greater claim to live free. No king, no priest, no celebrity, no judge, not any person has any greater right to walk free than any lowly carpenter, plumber, or law-abiding street minstrel. We are all equal in the sight of our law. Of course, if we violated the obligation and responsibilities that arise from the privileges our laws provide, then we may lose our liberties. If we murder, lie, or steal, we are in violation of law, and the law has a remedy. Our courts can take our liberty away. If we refuse to love our neighbor as ourselves, the law can limit our liberties or even to take our life if the crime is sufficiently outrageous. But so long as we obey the law, we are at liberty to love, to live, to laugh, and to enjoy all the benefits life has to offer any other human soul, regardless of our heritage, financial circumstances, our political advantage. The right to liberty does not grant a right to take what others have. The right to liberty does not grant a right to demand material wealth. The right to liberty is a power to do with our own lives whatever we may choose to do, using whatever we have at hand to accomplish our goals. But it does not give us the right to take from others. It does not give us the right to lie about others. It does not give us the right to limit the liberties of others just because we don't like their opinion or the way they dress or the things they say. The right to liberty is the right to obey laws and, while obeying laws, to live free from interference by the state or others. This should draw attention to the red flag laws, ladies and gentlemen. This here should open your eyes to a number of atrocities that happen day in and day out by your neighbor being a squealer and squealing on you for doing something that you enjoy that doesn't necessarily cause them harm, damage, injury, or loss. And thus, you run the risk of having agents and agencies show up at your house, thought policing, and arresting you or accosting you against your will or stealing your right to defend yourself with your defense tactical tools. And so it's very clear. I hope people are tuning into this and will listen to it multiple times because there's a lot of great information in this. Liberty is a great privilege, so the obligation and responsibilities that go with liberty are also great. We in this nation risk losing our liberties because we too often are unwilling to fight for the liberties of others and to grant special privileges. And what that means is, ladies and gentlemen, I don't care if you're a janitor or a CEO of a Fortune 500 company. If an agent and agency tramples upon your rights, they also trample upon mine. And if we allow them to continue to do these evil, sinister things to people, completely irrespective of their title or their rank in society or alleged society, if you will, just know this to be true. If an agent and agency violates your neighbor and you remain quiet, you just the same had your liberty violated and your rights violated as well. because to have one man's rights violated in this nation is an atrocity and a violation against every man and woman's rights in this nation. So pay attention. We share an obligation and responsibility to protect our neighbors from the exercise of unlawful power, justice for all, privilege for none. The safety of the people is the supreme law. One problem society faces is not knowing how to judge their laws. What is the principle? How do we recognize good law as good and bad law as bad? The maxims give us answers. Man's law must submit to higher laws. The supreme law is that all laws must promote the people's safety. Any law that fails to promote the safety and well-being of the people is a bad law. For example, suppose your state passed a law that authorized a particular company to transport dangerous substances in flimsy containers, and as a result, people were injured. Such a law does not promote the people's safety. According to this maximum, such a law would be illegal pursuant to the supreme law. Since good laws promote the people's safety, any law that fails to promote people's safety is an illegitimate exercise of state power. The people's safety comes first. The posterity of any particular industry, individual, or minority subculture within society is never more important than the safety of all peoples. And any law that promotes the posterity or a single industry, individual, or subgroup within society to the detriment of the people themselves is illegal because it violates the supreme law that the people's safety comes first. Too many private interest groups, political action committees, and lobbyists succeed in getting legislators to enact laws that favor a few but are bad for the people in general. The proponents of these laws argue that their private interests deserve a break or that the selected few are somehow more important than the many. These arguments violate the maximum. Laws these people seek to enact are illegal because the people's safety is the supreme law. All laws that violate this maximum are bad or bad laws and should be repealed. But not only that, not only are they repealable, they're null and void, in abitio, from the beginning, ladies and gentlemen. The safety of the people cannot be judged but by the safety of every individual. The maximum teaches us where individual rights come from. Since the safety of the people is the supreme law, this maximum tells us how to judge the safety of the people. It's not just the safety of the majority that counts. It is the safety of every single one of us individually. If a law is bad for any innocent individual, it is bad for all. Suppose your state passed a law making it a crime to have blue eyes. Brown-eyed people are in the majority, about 3-1. So the majority could conceivably pass a law making it unlawful to have blue eyes. Some scientific evidence might prove that the blue-eyed people are more likely to commit crimes. Some brown-eyed folks could condemn blue-eyed people to death. After all, majority rules, or does it? In civilized society where maximums are upheld, the majority is prevented by the principles of maximums from wounding the minority. Maximums teach us that every individual must be safe or society itself is not safe. This principle protects minorities from the majority. These truths need to be taught to every generation. They protect us all from the abuse of law that always results where such truths are hidden from the people. The maximums teach that only by evaluating the safety of every individual can we gauge the safety of society itself. It's good to support legislation to protect minority groups and individuals from being invidiously discriminated against by society's laws. But until we use our maximum power, we are merely fighting political battles. Politics alone cannot make the world safe for individuals. The need of individuals and minorities must be protected not only for the sake of individuals and minorities, but for the sake of the society in general. This is self-evident truth, and it is expressed by this maximum. The safety of society cannot be judged but by the safety of every individual. If anyone, however, insignificant he or she may seem, is being unfairly wounded by our laws, government, politicians, etc., then those laws are wrong and should be repealed at once. The power of maximums outweighs the imperative of the majority. If any law unfairly wounds just one innocent person, that law violates this maximum, and the law should be changed. Legitimacy of government. Unjust is state power where the law is either uncertain or unknown. Okay? It has been said the power of the state arises from the consent of those whom the state governs. However, the truth is that all state power derives from laws alone. Laws create the state and justify state action. In a very real sense, laws are the state. To the extent people know the laws of the state and consent to their enactment and enforcement, the state is just because it is truly consensual. If laws are either uncertain or unknown, however, the state is unjust and should be altered. For this reason, public legal education is a moral imperative, for only by public legal education can laws be known and their exercise by the state be just. Unless people know the laws that give the state power to control their lives, the consent that would validate the state's power is not informed consent. Consent by force or ignorance is not consent at all. It is coercion. Government rule by laws that are uncertain or unknown is not consensual. Therefore, unless the state teaches its people the fundamental laws upon which it predicates its exercise of power over them, the state's power is unjust. Many today seek to reform the world based solely on an unstructured vision of future happiness. They don't realize the path to the future depends on abiding by principles, since they are unacquainted with the maxims of law. They often act without regard to self-evident truths set forth for us by maxims such as this, and the result is repeated failure. In their well-intentioned search for peace and prosperity, they fail to see the consequences of acting outside the self-evident truth that ultimately determines every outcome. They believe they can enforce their new world vision by enacting laws without regard to maxims. Being goal-oriented, they miss the method needed to achieve their goal. They are too focused on the outcome and too willing to accept whatever means are offered as expedients. Rather than resorting to the wisdom of the past to chart their course to the future, they forge ahead with novel experiments that ignore the self-evident truths that always control outcome. Visions of the future happiness and peace cannot replace tested truths taught by these maxims of law. We need to revisit the maxims so we can effectively change our government and make life better for everyone. This maxim teaches you that state power can only be justified where the people understand the laws by which that power is exercised. The corollary of this maximum is that state power can only be just where the state makes a reasonable effort to educate its people in the things of law. The state should be subject to the law, for the law creates the state. Without the law, no state could exist. No nation, no country, no county government, no international force, no state of any kind can exist without laws, for it is by laws that states are created. This maximum teaches us that, just as the state is created by laws, so the state must be subject to the law. And, of course, every state should be subject to these principles of law, for only by the principle of the law can we judge the state as just or unjust, wise or foolish, strong or weak. The old saying, "What's good for the goose is good for the gander," comes to mind. Only the government government willing to submit to the law is justified to require others to submit to its power, for its power derives solely from the law. A government that proclaims itself entitled to do completely as it pleases while requiring its people to rigidly obey every precept of its legislation violates this maximum of law. Such governments are unjust, and their leadership should be changed immediately for the sake of the people whom they are charged by these maxims of the law to protect. How can the exercise of power be justified in the hands of a government that is itself lawless? It cannot. The exercise of state power is only legitimate to the extent that the state itself submits to the legal principles, of which the maxims of the law are supreme. No state has a lawful right to act outside of its own laws, nor does any state have the right to create laws that violate the maxims of law. This should be obvious. The legal maxims are self-evident to everyone but those who, for selfish reasons, refuse to submit their private interest to the good of all. It is self-evident that states should be subject to the law, yet news reports today are too far frequently peppered with stories about government action that is contrary to the most fundamental laws of the land and clearly contrary to these maxims. The judge who decides a case without hearing both parties, though his decision be just, is himself unjust. This is the first principle of due process. This is the bedrock of justice and fair play. Everyone should be heard fully, completely, under oath, without threat, duress, and coercion, without being told to shut up, or without being told that their point isn't relevant, or that they're off the scope. All right? You have a right to be completely and fully heard. All right? Because, after all, we're talking about taking a man or woman's life from them or impeding their life in some form or fashion as a way of punishment, right? So everybody has a right to be heard completely. All right? Under oath. If a party has witnessed, those witnesses should be heard. If a party has evidence to present, the evidence should be examined, not stricken from the record, not stowed away or hidden, not told by any judge that evidence is irrelevant and won't be seen in my court. That's a bunch of horsepucky, ladies and gentlemen. All right? So if you know this maximum, when the judge starts trying to throw his weight around and throw your facts and evidence out of the court, you can hold them to it. If the witnesses are not trustworthy or the evidence is inadmissible according to the law, the party should nonetheless have a chance to offer the testimony and evidence until they are shown to be improper, all right, which means properly challenged. Under no circumstance should a party be denied the opportunity to at least offer witness testimony and evidence. And certainly under no circumstances should the cause of any person be judged until that person has been heard by the court explaining his or her side of the story. Many people today are so anxious to see justice done, they are willing to acknowledge that justice really is. They are unwilling to acknowledge what justice really is. Some believe it is so important to punish evil that it does not matter how the punishment comes about, so long as doers are required to pay for their crimes. The maxim teaches us that punishment of an evildoer without affording due process of law, ergo without allowing the person to be heard and present witnesses and evidence in his behalf, is itself an evil deed, a wrong performed by the court itself. Even where the court is convinced of a party's guilt, if the judge does not give that person an opportunity to be heard and to present witness testimony and other evidence in his or her behalf, the judge is not just, and an order of the court entered in such circumstances violates the rule of law. Indeed, no matter what the party's guilt may be, the unjust act of the court of law is an even more guilty crime. Only when the people understand these fundamental principles of the law, once reserved and generally upheld and honored by civilized people throughout the world, can we hope to reestablish justice and liberty for all. Courts are for the people to command the power of the state. Our courts belong to everyone. They belong to you. They belong to your family and loved ones. Our courts exist for one purpose only, so the people have a place where they can command the state to keep its promise to the people. Our courts belong to the people, not to the state. They are ours. They offer hope for the oppressed, relief for the victims, justice for those who are wounded. They serve no other purpose. Our courts exist solely to give people a voice whereby we can command the power of the state directly. The polling booth is only one of our powers over government. Our courts are another, and in many ways are far more powerful than the popular vote. The power of the people is nowhere stronger than in our courts, where the people themselves command the state to obey the law by granting remedies, justice demands, and for those who come to the court for grievances. Our courts are operated by the state. Our courts are run by the state employees, judges, bailiffs, clerks, and judicial assistants. But the courts belong to us. They are there to protect our interest, not to advance the causes of the state, nor to favor the causes of special interest groups or powerful political action committees. You have the power over the courts. That's right, you have the power to command your courts to obey the law. That power is contained in the rules of the court. Rules of evidence, rules of procedure, rules of judicial administration, and the maxims. Laws that control every judge, lawyer, officer of the law, and every party who comes before its bar. The courts are subject to the law, and your knowledge of the law commands your power over the courts. Too many complain about injustice, refusing to see that injustice is merely the natural consequence of not knowing how to enforce the law. Since courts are subject to their own rules, the power to control the courts is in our knowledge of those rules. Surprisingly, those rules of the courts are fairly easy to learn. In many states, the fundamental rules of the court are quite simple and concise. For example, the official rules of evidence in Florida comprise less than 30 pages. These are rules your court must obey. When more people know the rules, fewer will complain that justice was denied by their courts. Courts give people power to control the state. The burden. The burden of proof lies on him who asserts the facts, not on him who denies it, because for the very nature of things, a negative cannot be proof. This is the law in every court of our land. It is also a key to winning in a court of law. For decisions courts are called upon to make are always subject to this maximum. The burden of proof is a critical issue in every dispute. The burden is always on the person who seeks to prove his point. The other party does not have a burden to disprove his opponent's point. It is remarkable how few people are aware of this simple truth. Yet every victory in court depends on it. If the other side says you did something wrong, you don't have to prove you didn't do it. The other side has to prove you did. Put the burden where it ought to be. The burden may shift from one party to the other in a dispute. For example, the first party may complain that the second party failed to pay a bill. At this point, the first party has a burden to prove his point. The second party may then say he did pay the bill. At this point, the second party now has a burden to prove the bill was paid. The burden may shift back and forth at various times depending on who is claiming what, but always the burden is on the party who must prove his point. The burden never shifts to require a party to prove the other party is wrong. Maxims such as this protect the innocent. They are an important part of our American legal heritage. They deserve public attention and should be taught in all our schools. For by the wisdom of these maxims and the self-evident truths, they teach our people are protected from adversity and justice is preserved for all. Testimony and evidence. No one should be believed in court except upon his oath. This maxim must never be ignored, nor overruled, for justice is found in the truth, and truth alone. Every person who seeks assistance from our courts should promise the people whose assistance he seeks, the courts belong to the people in America, that he will tell the truth or be subject to the criminal penalties for perjury. It's really that simple. A party who will not promise to speak the truth is not worthy of the court's help. A witness who will not promise to speak the truth should not be believed. We require everyone who speaks in our court to promise to tell the truth and to give this promise on their oath, solemnized by reference to God. God is truth. The God of the courtroom oath is not defined by any religious denomination. So, that brings up a good point. The God of the courtroom, right? Well, I don't know any God of the courtroom. And that's why my yay be yay and my nay be nay, because I don't swear an oath to a God. I never have, and I never will. But my yes be yes and my no be no. All right? That's my affirmative statement. Okay? Because you don't know what God they're talking about in that. Maybe God, Satan. You don't know. You have no idea. So that's why you're being told in the good book that you never swear an oath under God. You don't do it. All right? It's not defined by any religious denomination. The God of the oath is nothing but the truth. Truth that is, truth that was, truth that will always be. The God of the oath, okay? So what is this? This is a false God, right? I mean, they're telling you here that the God that you're swearing an oath to in a courtroom is the God of truth, the truth that always is, the truth that always was, the truth that always will be. That is not the divine creator. The God of the oath is not subject to man's interpretation. The oath does not require a witness to subscribe to religion. The oath is a solemn promise to honor the truth at all times while speaking before the court. Well, why not just say my yes be yes and my no be no until some other man can testify with first-hand knowledge that I'm completely full of shit, right? All right, there we go. That goes to prove my point on that. The promise is made not to God, but to us who are the government in America. Okay, so again, we're using the term God. We really are meaning the term God to mean government in America. All right, are you catching on to that satanic horse shit in court, where they're asking you, do you swear to tell the whole truth? So help you God. They're calling themselves God. Government is God. All right. I don't know about you, but I'm not supposed to have any gods above the Heavenly Father, the Divine, and I damn sure am not going to start now. We the people have a right to require those who come to us for relief to honor truth, and we have a right to punish those who dishonor truth with lies, subterfuge, and legal chancery at our expense. It really is this simple. Life, liberty, and the pursuit of happiness may be inalienable, and it should be unalienable rights belonging to every human soul, every man, woman, and child. Human is the color of man, hue being color, and then man, color of man. Whoever the right to demand assistance from our court carries with it a responsibility to honor the rest of us who make the courts possible by presenting only truth. Legal relief for alleged injuries is not a God-given right. It is a privilege provided by the people acting through government. And accordingly, this privilege, like all privileges, has obligations and responsibilities. The privilege to complain of injuries, and seek help in our courts by judgments and enforcement of the laws rests on the requirement that one promises to bring no lie before the court or be subject to the penalties of perjury if the oath is violated. This maximum, like all maxims, is a statement of self-evident truths intended to protect you and your loved ones from falsehood and deceit. Well, ladies and gentlemen, what are they doing to you on the side of the road when they're forcing you into a contract because of your ignorance? Are they doing falsehoods and deceit? And is the court facilitating them in order to generate wherewithal credits on accounts by securities? Absolutely. So are our courts really our courts anymore? No, they're not. They're admiralty courts, and they've been that way since 1871. So what can we do about it? Well, learning these maxims may just help you out in your time of need. Liberty is impossible without justice, and justice is impossible without truth. Courts should not believe water runs upward of its own accord, nor that impossibilities exist. All right? And this is a really good one when it comes to you paying alleged bills and debts, because there is no substance in the economy. And so what have we created here? What did the government create? An impossibility for every man, woman, and child to ever pay a debt. All right? That's why Title 18, subsection 8 is so powerful. All right? And so let's get into this. One of the great stories of American justice is a case in which Abe Lincoln, as a young lawyer before he was elected president, was defending a man named Armstrong, accused of killing a man in a nighttime brawl. State witnesses claimed to recognize the accused from a great distance in the darkness. Lincoln convinced the jury to acquit his client by referring to an almanac for the year of the crime. It turned out the moon was new, and a new moon is a moon where it doesn't reflect any light. So, new moon on the particular night. So it would be impossible to recognize the murderer from such a great distance on a dark moonless night. Impossibilities have been established. Lincoln's client went free. Too often, people tend to think of a court proceeding somewhat like a family squabble where anything goes. Too often, the party who shouts loudest or brings the most impressive exhibit or parades the best dressed attorney before the jury is the party who wins. And too often, truth is obscured by wishful thinking or merely by unwillingness to demand clear proof. Water does not run upward of its own accord. Things that are impossible do not exist outside fables and movies and movie theaters. To judge a case by believing in the impossible is to deny justice. On occasion, miracles do take place. However, maxims were given to us so we would not permit the unusual or bizarre form outweighing common sense in our courts. If a miracle actually takes place, then let the party asserting the miracle meet his burden to prove the miracle took place. Never is it just for a court to believe impossibilities exist. Never. To allow such divergence from our legal maxims is to undermine our entire legal system and open the door to all sorts of travesties and crimes against justice. It is better to set one guilty man free than to destroy the very fabric of our legal system by permitting courts to believe in things that cannot be proven true. Better to release 100 hardened criminals than to punish one innocent soul without sufficient lawful evidence. Truth is the essence of justice. Without truth, justice cannot exist. Hold fast, America, let the self-evident truth of our legal maxims guide you in your quest for justice. Ignore the parades of charlatans and cheats who seek to turn your heads with fables and dark mysteries, especially in your courts where the truth must forever be sought above all else. The certainty of things arises only from making the things certain in court. Of all requirements of justice, none is more sacred than proof. Upon proof and proof alone, decisions are justified. Where there is no proof, there is no justice. Proof depends on establishing certainty. A thing made certain is proved. Too many are willing to consider a thing made certain based solely on the reputation of a witness or the appearance of a party's lawyer, or the way an accused man fidgets with his hands. There is no certainty in such things. To prove a thing, it must be made certain, not merely probable or possible. The credibility of the witness may be relied on in giving weight to what a witness says, but unless the point is proven by being made certain beyond doubt, then proof has not been established, and justice has no place to stand. Justice stands solely on truth. Truth, on the other hand, is certain, or it is no truth. The maxims of law put wise limits on the power of the courts. These limits are good things, for they protect innocence far more often than they fail. Too many good people suffer injuries in our courts because a proof was not made certain at all, but depend on an intentional accumulation of innuendo, unfounded accusations, or an emotional outpouring of rhetoric that goes beyond proof courts should require. Far too often, passionate expression of hatred or contempt for an accused person results in conviction while no certainty was ever established. Upon such unfounded judgments rests the greatest crime of mankind against mankind. Only where a proof is made certain can it truly be called a proof, and only by proof can justice be established. No citizen should be deprived of the benefits of this maximum, however low his status in life may be, however heinous his past deeds may seem, however ugly or distorted by life's trials and consonants of such person may appear to us who are called to judge that person for a crime or injury to others, regardless of our personal feelings. If a thing must be shown to be certain before just judgment can be rendered, then the certainty of the thing should only be considered when it is indeed made certain, testable, provable, and true, for there is no other way to make a thing certain. To enter judgment on an uncertainty is to subvert and deny justice. Civic duty of citizens. Each should use his own powers and property so as not to unjustly injure others. Each of us possesses an unalienable right given by God, our Creator, to enjoy the benefits of life, liberty, and the pursuit of happiness. Powers afforded by law, such as the right to own property with law's protection. However, our privileges with obligations and responsibilities that attach to all such privileges. The first obligation attached to the power and ownership of property is that no person has the right to use his power and property to cause injury to others without cause. If an innocent passerby walking down a country road outside the fence of your farmland is kicked by a mule that escaped from your farm because you did not keep your fence in good repair, then you are responsible for his injuries. On the other hand, if the passerby takes a shortcut through your field and is chased by a bull, injury to that person is not unjust. The passerby is a trespasser. His injury is not your responsibility. In a great majority of cases before our courts, the question to be decided is to what extent an injury to one party was justly or unjustly caused by the other. This maximum teaches us that no one has a right to use his power or property to cause harm to an innocent person under any circumstances whatsoever. There are no exceptions. This maximum is part of our legal heritage in America. He who causes injury to an innocent person through exercise of his powers or use of his property is subject to the judgment of our courts to remedy the injury. It doesn't matter if the injury results from negligence or not knowing. All right? Gross negligence equates fraud, ladies and gentlemen. If the use of one's power or property injures another who is without guilt, our courts owe a duty to provide the injured person with judgment for his injury, even if the injury was only accidental. If you intended injury to another, you may be found guilty of a crime, perhaps a felony, that results in your being sent to prison or put to death. Our courts take very seriously the responsibilities of privilege. Each of us is obligated to all others when more people know our maxims of law. There were there will be fewer injuries. The power of our courts should act quickly and decisively to preserve justice and grant remedies to those without any fault of their own suffer injuries. Private property. There is nothing more sacred, more inviolate than the house of every citizen. Fortunately, in most jurisdictions, this maximum is still enforced by codified law. Search warrants are usually required before officers of the state can enter a man's home. Of course, if officers have a reasonable good faith belief a crime threatening bodily harm or death is being committed in a crime, they need no warrant. If a man or other if a man or woman is peacefully abiding in his or her home, however, this maximum secures the right to enjoy life secure from unreasonable seizures and searches and seizures. Due process is nowhere more critical than when it requires officers of the state to have good cause before entering a home. It doesn't matter if you live in a mansion or a two-room flat up 3 flights of stairs. If it's your home, the maximum offers your protection from others. Before entering a home, therefore, officers of the state should have warrants signed by a judge of competent jurisdiction, and the warrant should be supported by an affidavit. Now, when they use the word should in here, it's must. The answer to that is must be supported, not should be, must. All right? It must be signed by a judge. It must be supported by an affidavit. Facts alleged in writing under oath, setting forth why the warrant is needed, what crime is believed to be taking place in the home, giving a reasonable description of the known facts giving rise to this belief. No warrant should issue except upon sworn written testimony. A man's house is his castle. Thus, within his home, he should be respected by his neighbors and by officers of the government in the same way a king's palace would be respected, equal in right to the highest power of the land, unless he is abusing this right by causing harm to others within his home. Maxims such as this protect us from unreasonable exercise of state power. Every home is a castle. Though the winds of the heavens blow through it, officers of the state cannot enter. This maximum is basic to our American concept of liberty. For although the streets and thoroughfares belong to others who have a right to protect themselves from what you do in public, your home is protected by this maximum from invasion of force for any reason not specifically authorized by legal process. It doesn't matter if your home is a mansion on the bay or a rented one-room apartment. It is your home, and without proper authority given by the law, no officer of the state has any right to enter. The teaching of this maximum has never been more needed in America, for in recent years legislators have made it easier for governmental officials to enter your home at any hour of the day or night for the purposes that would have been illegal in the past generations. Proponents of this modern thinking claim they are protecting the public's welfare, but the welfare of the public can only be judged by the welfare of each individual. Where one has no sanctuary from abuse of power, the welfare of every one of us is at stake. Hold fast to this maximum, for it protects you and your family from abuse. If a person is making dynamite in his basement or holding innocent children hostage at gunpoint, the right to be secure in his home is outweighed by the right of those who are threatened by his activities. In such circumstances, officers of the state not only have a legal authority to enter, but the moral duty to do so. No person should be permitted to use privileges to injure others. Therefore, no person should be permitted to harbor harm in his home without being subject to the arm of the law. Officers of the state should never be permitted to enter a home without due process of law, a warrant founded on an oath supporting probable cause to believe a crime is being committed or is about to be committed in the home. Without such due process and requisite oath, the invasion of our homes is a violation of our rights to liberty, a right not given by government but by God. The enumeration of our God-given rights is the purpose for legal maxims. By publishing the maxims of law, we learn to agree what our fundamental rights truly are and can work together to preserve them for future generations. Title is the right to enjoy possession of that which is our own. One of the principles of liberty upheld by the American heritage of law is a right to hold title to private property. Property can be land or things, money or securities, promises or judgment, securities, ladies and gentlemen. What are they dragging you into court for? Because I hypothecated your credit and they've created securities. And you are entitled to them because they're what? Property. And you have a right to your property, land, money, securities, promises, or judgments. All these are forms of property in which we are given the right by government, and that's a big no-no. We're not given a right by government at all to hold these titles. These titles are self-evident, ladies and gentlemen. So there are things in this literature that I strongly disagree with, but I'm going to continue to read on. But government gave shit. We created the government, thus they give us nothing. Nothing that we don't condone consent to, period. They've given us nothing. If anything I learned about the studies that I have invested my time into is government has denied we the people things, has stolen from us, has taken, all right, hindered our fellow man. So we'll go on. To hold title. Government never gave you no damn right to hold a title, period. You had it naturally. But what does the title mean? The Maxim tells us title is the right to enjoy. Title is the right to possess. Title is the right to say such and such a thing belongs to us and to no other. If we hold title to a particular property, whether it's a home or a collection of rare heirlooms, we have the right, protected by our courts, to enjoy the exclusive possession of that property. If we hold title, we can call the property our own. If another takes possession of our property without title, we can appeal to the court for a remedy. If we cannot prove our title, the court is required to restore to us our possession and enjoyment of our property. In some cases, the person who takes possession of our property may be required to pay money to compensate us for our loss or possession and enjoyment. Without title, however, we cannot prove our right to enjoy possession. Title is a form of proof. Title to land, for example, is usually proven by a deed. But if you didn't accept that deed, ladies and gentlemen, you didn't do an acknowledgement of the deed, then you don't rightfully have a deed. I could give you a car, but if you don't take the keys, you don't have a car. All right? Title to such things are cars or furniture may be proven by bills of sale. In some cases, title may be proven by a simple cash register receipt or a scribbled note signed by the previous title holder. In every case of ownership, however, there must be some form of title. Now, something I want to touch base on here. A bill of sale is, in fact, ladies and gentlemen, a title. And when you gift that to the state, you have then gifted your bill of sale, you have gifted your original property to the state, and in lieu, they give you a colorable title. Now you need permission to use the state's property, which you voluntarily gifted to them, to utilize it. And there's where you're paying your property tax, and that's where you're paying your place and registration on your automobile, because it's not yours anymore. You gifted it away and you got rid of the bill of sale and you gifted it to them, and they issued you a colorable title. There must be some form of title, even if only word of mouth. Proving title, of course, is easier where proof is in documentary form. Writings, that means requirements of law. For example, in Florida, most forms of title to real property require a document signed by the person conveying the property and also by the by at least two witnesses, which is biblical. Everything should be witnessed by two. It's biblical. Failure of probable title divest the court of authority to establish the right of ownership, possession, and enjoyment. This maximum teaches that the right to enjoy possession of property we claim to be our own must be proven by some form of title, and that enforcement of our right and title depends upon that proof. This protects the rightful owners from the claim of those who have no right or title. Civil rights. No one should be required to betray himself, i.e., no one should be made to testify against himself. This maximum is the foundation for our Fifth Amendment, that none of us be required to give testimony against ourselves. It derives in part from the maximum that requires a party asserting truth to be required to prove the truth asserted. Thus, the state, in charging a citizen with a crime, bears the burden of proof to prove crime without getting any help from the accused. The burden should be entirely on the accuser. Where this maximum is upheld, an accused person may remain silent before his accuser without guilt being inputted to him in any way. It is an American point of law worthy of our continued support. Other nations do not agree with us about it. This maximum protects our liberty. Before the state can lawfully deny liberty to any citizen, it must meet its burdens to prove that person broke the law. The citizen does not need to prove his innocence. The state must prove his guilt. The state cannot lawfully require any accused person to confess his guilt, nor present any argument in defense of the charge against him. The burden is entirely on the state to prove its case. So, in court, when they're saying, Mr. Gonzalez, the charges being brought against you are such and such, such and such, such and such, and I think you ate a Twinkie that led to you gaining 2.5 pounds, which puts you in the obesity range. How do you plead? Well, if I must plead, I plead that fat bastard sitting to the right of me, acting as the plaintiff on behalf of an alleged victim known as the state, who he doesn't actually have a contract with, showing that he has power of attorney over the state, or even a contract to even represent the state. I hope that fat bastard over there surely can frickin' prove his damn case. That's how I plead. I hope that bastard over there can prove his case so I don't have to sue him for harm, damage, injury, and loss. That's what I hope. How's that for a plea, right? Many people believe this principle lets guilty people get off. Too many of these otherwise reasonable folks favor abandoning this maximum. They would require a person accused of a crime to submit to examination that might tend to incriminate him. It should be understood by all of us, however, breaching this maximum will, in the long run, do more damage to society than allowing one or two guilty persons to go free. For by breaking the maximum, we open the door to abuse of the state power by divesting innocent people of the right to remain silent. This we should never do. By preserving the maximum, we preserve our American legal heritage. Always in society, there is a struggle between those who wish justice at any cost and those who realize state power can be misused, a force that must be kept under control by principles. Maximums such as this keep us from veering off course. This maximum is so important, our nation's founders wrote it self-evident truth into our Fifth Amendment, so all states would be required to keep its teachings. Like all maximums, it should be scrupulously enforced, hold fast, allow no compromise. Everyone should be presumed innocent until guilty is established beyond a reasonable doubt. Well, Your Honor, you're asking me to plead, but is it not true that everyone should be presumed innocent until proven guilty? Yes, it is. Then why the hell are you asking me such a foolish damn question? I think your question needs to be directed at the plaintiff, the alleged guy representing the state with no victim, no injured party, no malum in se, no malum prohibitum, no corpus delicti. Didn't you mean to ask that question to dickhead over there? You see? Because they're trying to get you to plead to something. And remember, when you deny something, it's better off to admit something than to deny. Tensions exist between promoting a safe society by punishing wrongdoers, and preserving a just society by requiring courts to obey maxims such as this. In every age, there are those who believe it doesn't matter. If few innocent people are punished now and then, so long as evildoers are locked up or executed. These people have good intentions but fail to see that it is more important for our courts to protect innocent people from injustice, to ensure justice for the innocent at the expense of failing to punish every evildoer. This maximum requires our courts to prove guilt beyond a reasonable doubt or acquit the accused. Better to release a few wrongdoers than to allow a system of laws that is itself unjust, capricious, and cruel. This maximum teaches us that it is more important to have a just system of law that occasionally fails to punish than to have an evil system of laws that is permitted to punish the innocent. Many today wish to destroy the principles of due process and ignore the rules of law fought for by our forefathers, so the state can punish every soul they believe worthy of punishment. Yet this maximum wisely values mercy more than judgment and forgiveness more than condemnation. America was born as a reaction to this abusive practice of European courts, where the innocent were routinely punished without the protections our maxims provide. All power was given to the king, in whose courts people were routinely condemned to death, without benefit of counsel or even an opportunity to be heard or present witnesses in defense. America was born out of the abuse of justice that were commonplace in Europe when our Declaration of Independence was signed in 1776. In its birth, principles were set forth by legal maximums. On these principles, our laws and constitutions have been erected. To preserve our American Republic, sorry, I had a Nancy Pelosi moment there. I got something in my throat when I went to say republic. Son of a gun. To preserve our American Republic, we must preserve the maximums on which our legal system is built. The state must bear a burden to prove its citizens in error, and its burden must never be discounted nor set aside. In this maximum, it is protection for the innocent, and by this maximum, the greater cause of justice is preserved. No one should be twice harassed for the same offense. This maximum is similar to others that put a burden on the state to prove crimes with certainty or set the accused person free. The state is required by principles of justice to meet the burden of proof. It can present evidence in the form of witnesses and exhibits, but it must permit the accused to present evidence that discount state evidence. Each side presents its case in accordance with strict rules, state going first and the accused person following with his defense. If the state fails to carry its burden to prove the crime beyond a reasonable doubt, and let me stop right here. First of all, if they're bringing an action against you, you need to immediately file a counterclaim. Why? Because when you file your counterclaim, you're going to be heard first. You have an opportunity to put the final nail in the coffin right out the gate. So always bring your counterclaim and become the plaintiff instead of the defendant. Why? Because the defendant always loses, people. The defendant always loses. If somebody's bringing a false allegation against you, you have a duty to bring a counterclaim post haste, absolutely immediately. The accused goes free. Once an accused person is set free, the state cannot again try that person for the same crime twice. The state had its chance and failed to carry out its burden. To give the state another bite at the apple would be to deny the accused his rights to justice, for justice requires the state to carry its burdens or acquit. Both sides have one chance and one chance only to make their story clear. If the state fails to carry its burden of proof in the first attempt, the accused person goes free and cannot again be tried for the same offense. The point of this maximum is common sense when viewed in light of the other maximums, for only if the state is required to carry its burdens in the initial proceedings can justice be secured. Otherwise, an accused person could be dragged back into court repetitively until the state finally found a jury willing to convict. That is contrary to the principles of justice that require the accusing party to bear its burdens of proof. This maximum is embodied in the Fifth Amendment to our Constitution. Only by adhering to maxims of law and understanding the self-evident truths on which they are based can we preserve liberty and justice for future generations. Because the very nature of liberty and justice are found in maxims that are the very expression of those virtuous, without liberty there can be no justice. Without justice there can be no liberty. Without maxims we have no way of knowing which is which. Administration of justice. He who slices the pie should be last to take a piece. Seems like good common sense, right? Here's a maximum that should be observed more often. Too often those who divide property or hand out favors are first in line to receive the benefits. Clearly, if the person who is allowed to cut the pie is also allowed to take the first piece, in some cases there won't be much left for others. This maximum points out the error in such thinking and protects those who might be abused by selfish people. Fairness is secured by the principles like this. The maxims teach us that fairness is and what fairness is and how it can be enforced for the good of all. In our courts, this maximum is used to determine who goes first, i.e., which party gets to address the court before the other, and who goes last, which party gets to have the final word. The first is last, the last is first, normally. The complaining party, plaintiff, in civil cases, state and criminal cases, goes first, putting on witnesses, offering exhibits, doing the best it can to prove the facts it needs to win. The complaining party has only this one chance to demonstrate its entitlement to a judgment. It gets one bite at the apple, and then it must sit down, i.e., it must state its case, then it must rest. The defending party is then permitted its after the complaining party has done its best. The defendant may move the court right then for judgment based on the complaining party's failure to meet the burden of proof. If the defense cannot prove the other side failed to meet its burden of proof, it presents counterbalancing evidence in an effort to overweigh the merits of the complaining party's case. The complaining party gets to cut the pie. The defending party gets to take the last piece. If there are opening and closing arguments, the same rule applies, so the complaining party opens first and defending party closes last. The complaining party gets to make the first impression, but the defending party gets to have the last word. The goal is to make the process as fair as can be. Whether cutting pie or making case arguments before the court, this maximum promotes fairness. It wouldn't be fair to let the complaining party go first on opening statement and also have the last word at closing. Judicial reasoning. Words should be considered only as commonly understood and not with a meaning other than others construe to their own purpose. Boy, oh boy, this maximum right here is dangerous to all lawyers. Why? Because they're using Black's Law Dictionary, which is a bastardization of the language, ladies and gentlemen. Words should be considered only as commonly understood, and not with a meaning others construe to their own purpose. Susie doesn't have quite enough money to buy a piece of candy. She needs only 3 pennies more. Johnny has 6 pennies. Susie asks, "Do you have 3 pennies, Johnny?" "No, Susie," Johnny answers. Construing his words to his own purpose, he has 6 pennies. Johnny sees it. Susie didn't ask her question precisely enough. He thinks to himself, "It's not a lie. I do not have 3 pennies. I have 6. Though Johnny chooses to construe these words to his own selfish purpose, this maximum makes clear that he is wrong, and our courts should not give into such deceitful tactics. Secretly using words while holding to a private interpretation is lying. Any time we use words to deceive others, we are lying. Whether or not the words have a secret meaning only explained by by a private interpretation or not, the goal of maxims is to bring light to the darkness, to hold up truth as the standard of fairness, and thereby ensure justice for everyone. Without the maxims, we have no guides, no standards to promote peaceful understanding, purposely using words with a hidden meaning, hoping others will depend on the common meaning reasonable people would expect the word to mean, thereby gaining an advantage over others, is dishonest. It is fraudulent. In extreme cases, it is a crime. Using words in particular ways to take advantage of others who can be expected to believe the words mean something else is wrong. Therefore, when our courts interpret a contract or witness testimony or other words that affect the outcome of some dispute between parties, they are reminded by this maxim to give words common meanings, and not to allow one party to insist that any word means something special. Courts routinely uphold this maximum. If you note it for the record, excuse me, Your Honor, it appears to me that this guy is bastardizing language, and I want it known for the record that all words used here today will have common meanings of the common language in English. Duly noted. Noted for the record. Judge, can you note that for the record? It's noted for the record. When making agreements with others, therefore, we should use words in ordinary sense, the way most reasonable people would expect to understand the words, and not in any special way that might be misunderstood by others. For if the matter goes to court, this maximum will be upheld in order to establish justice. Maxims such as this help us discern between right and wrong. Words should be interpreted most strongly against him who uses them. This maximum controls the outcome of many contract cases. One party usually prepares the written contract between parties. The other party usually assents to the wording by signing the contract, sometimes unwisely without even reading it. In the event of any dispute over what the contract means, however, this maximum tells us how to apply justice to resolve the dispute. When there is an ambiguity, i.e., a term or phrase that could mean more than one thing, the court will interpret the contract against the party who wrote it. This is what the maximum demands. The same principle applies, of course, to witness testimony or anywhere that one party makes a representation with words intending that another rely on them. If there is a question what words mean or how they affect the outcome of the case, this maximum requires that the words be interpreted against the person using the words. It is very common for this maximum to be applied by court, often without reference to the maximum itself, as if the principle were too obvious to argue. Every principle of justice should be written out plainly so we can all agree. That is the purpose of maxims. So we can agree what justice is and what it is not. Only in agreement can we maintain our form of government and pass it on to our children. Suppose you sign a contract prepared for you by a man who is selling you a house. You find that the house was not as he represented it in his contract, and he attempts to hide behind ambiguities in his contract, terms that could be mean more than one thing. If you sue, the court will construe the ambiguities in a light most favorable to you and against the seller who drafted his own contract. Maxims promote fairness, without which justice is impossible. Indeed, maxims define the limits courts must put on judgments so justice is served. Courts are not free to rule any way the judge pleases. Judges must obey the laws and stay within the boundaries established by maxims such as this. Crime and punishment. He who acts in pure defense of his own life or limb is justified. Necessity trumps law. This is the old self-defense defense. But please take note of the words pure and realize that if the action of self-defense was necessitated by a bad act, such as robbing a bank, and the self-defense was shooting back at policemen, the maximum does not apply. Only those acting purely in self-defense are excused for their actions. If you are attacked by a knife-wielding fiend who is attempting to take your life, you are justified in killing him with a pistol. But you must truly be in fear for your life. Well, Mr. Officer, you've been shooting 14-year-old women, kids, people, unarmed, in the back of the head, in the back, running away from you for quite some time now, and it is never justified. All right? And it's important. Our society has lost the basic fundamentals of law. It's only due to our ignorance that they're able to get away with the shit they're getting away with, people. When are you going to wake up? If a man pulls a knife to show you its pearl handle, for example, and you shoot the poor fellow dead, you are not acting in self-defense. Similarly, if you set a trap by which you arrange for a 12-gauge shotgun to go off if anyone jiggles your doorknob late at night, you are not acting in pure self-defense, and if someone is injured, you will be held responsible. Only if you are in present danger of mortal injury or serious physical harm are you permitted by this maximum to repel your attacker with force. Please also note that the force you use must be reasonable in light of the force being threatened against you. Well, let me help you out with this, ladies and gentlemen. I once had a second father to me tell me that a young man was accidentally killed in a street fight. And it wasn't the fact that he hit him so hard that killed him. It was the way he landed on the ball hitch. So let me just explain this to you. In every instance, it's a life or death situation because you never know how you're going to land. All right? So there's your defense for that. People, as far as rigging shotguns to go off if somebody tampers with their door, if you've got no trespass on your property and somebody's trespassing, they get what they got. The old adage, the screwing you get for the screwing you got, same kind of thing. You shouldn't be trespassing. You shouldn't be trying to open people's doors. You know damn good and well it's wrong, and if you catch some lead out of the deal, that's your own fault. For example, if someone attacks you with a feather pillow, you may be justified in snapping him on the legs with a wet towel to make him stop. But you cannot throw acid in his face nor stab him through the heart with a dagger. That would not be using reasonable force in light of the threat. You have the right to defend yourself with vigor, ladies and gentlemen. And just remember that. Use common sense. Use good judgment. On the other hand, if you are threatened with severe bodily harm or death at the hands of someone who has the present means to inflict such injury on you, ergo, a man at close range with a loaded pistol aimed at your chest, you are justified to use any force at your disposal to defend yourself from the threatened harm. But the threat must be reasonable, and if you are required to explain to the court why you did what you did, the burden will be on you to prove your acts were reasonable under the circumstances, i.e., that the force you used in self-defense was reasonable in the light of the threat. Well, for the officers out there, it's the way that you guys conduct yourselves, it's becoming more and more apparent that normal people's encounters with you is extraordinarily dangerous because you guys shoot unarmed people that mean no harm, that aren't doing anything. And so how are we to feel any remorse for you in your line of duty when you're shot? Because most often, you guys are busy abusing people, violating their rights, and quite frankly, I think anybody that encounters an officer anymore has a heart palpitation when they see those lights kick on behind them because they're not sure they're coming home tonight. So you want to talk about reasonable grounds for euthanizing assholes? You guys are creating it. So just remember that when you're out there on the beat. why people are so pissed off at you. Because you're abusing powers otherwise not delegated to you. You're shooting unarmed men and women in their homes, in the streets, and people, quite frankly, are in fear for their life when they encounter you guys. Think about that for a second. Being permitted to act in self-defense is one of the blessings of liberties that is secured for us by laws that abide by maxims like this. Just remember, the maximum is quite clear that your acts of self-defense must be pure. Well, I plan on going home tonight. I don't know how much more pure you can get. Motivated only by a desire to avoid injury to yourself and not by any hateful or retaliatory motive. So long as you act in pure self-defense, you will be justified by the law. Crimes are more effectually prevented by the certainty than by the severity of the punishment. This ancient truth should be more widely published in the world today, for it is as true today as it was hundreds of years ago when it was recognized by the jurists of old. Anyone with children knows this to be true. When a child knows he will be punished for stealing from the cookie jar, he is much more likely to count the cost than if he thinks he can get away with it. Whether the punishment is being grounded for a month or merely losing the right to enjoy dessert with the rest of the family, if the child believes there's a good chance he can steal a cookie without being caught, he will be much more likely to commit the crime. It is not the severity of the punishment that dissuades criminals so much as the probability of paying the price, so long as there's a chance of escaping punishment altogether. Most people who consider committing crimes are more likely to risk the possibility if circumstances are such that it is highly likely that one will not be caught red-handed in the act. However, most people will not take the chance. Severity of punishment is a factor, of course. If stealing a cookie means only one must go without dessert at supper, the value of the cookie might be worth the risk. A child might think, I'd rather have a cookie now and go without apple pie later. The possibility exists, of course, that the child can have the cookie now and still have pie later if he doesn't get caught. On the other hand, if stealing a cookie means amputation of the hand, as might be the case in certain Middle Eastern nations where thievery is taken seriously, most of us would consider a mere cookie not worth the risk. Of the two factors, severity and certainty of punishment, the wisdom of our maxims teaches it is certainty that tends most to discourage crime. A moment of reflection will reveal that this is self-evident. Okay, so for the officers of the law that have been getting away with raping women after handcuffing them, beating people senselessly and all that, there is no action by the court taken against these officers because these officers are they're needed in order to feed the thieves. So they're not going to punish the officers of the law for these vagrant acts that they're doing that are malicious and breach of their duty. Instead, they slap them on the wrist, give them paid time off, and they come back 2 weeks later to do the same purported shit again because we are not holding them responsible. And so the calculated risk and certainty is highly favorable in their favor due to their line of work. And because they're not being reprimanded in such a manner that would be conducive to correct the behavior, we see a litany of officers of the law, alleged law, abusing their office and abusing the alleged power that was granted to them for the security of we the people, which is, it's lunacy at its finest. Perjured witness should be punished for perjury and for the crimes they falsely accuse against others. Well, again, we look at law enforcement, and they constantly lie on the stand. They lie in the streets. They, through threats, duress, and coercion, get people to say certain shit because it's not about justice anymore, ladies and gentlemen. It's about revenue. It's about securities. It's about generating ledgers or credits on account that justify the existence of them even being on the street, on the beat. This ancient maximum is nowhere codified in American law. However, wisdom might be better served if it were, for one of the worst abuse of our legal system is perjury. Unless we enforce the truth in our public proceedings, we cannot possibly expect to secure justice for those who are entitled to our courts' protection. Truth and justice are inseparable. Justice cannot exist where false testimony is permitted. He who perjures himself to injure another commits a very grave crime. Do officers of the law perjure themselves every day in court to convict people and turn around and make victims? Yes, they do. And it is fitting that he should pay for his perjury by serving the sentence he hoped to impose on someone else by his lies. One of the Ten Commandments instructs us not to bear false witness against our neighbor, against our fellow brother, against our fellow man. All right? It's a crime to bear false witness against your fellow man. Perjuries injure people all too often in court. Therefore, for example, CPS, these lying, looting, pandering frickin' weasels, you ought to take a paddle from the Dazed and Confused movie, like they made in the 70s in shop class, and we ought to be paddling these guys' asses outside of CPS, because they're lying, looting, pandering thieves, seeking to get unjust enrichment and a pat on the back for stealing people's offspring. We ought to have wooden paddles off of a 1970 Chevelle with a 454 in it, just waylaying these bastards. Therefore, when the liars are detected in our courts, they should be severely punished. They should be put to the public with wooden paddles so we can spank their ass to dissuade others from lying. Wouldn't that be a bit of humility? Bunch of angry parents out there leaving some nice welts on some adult CPS agent's ass out there in broad daylight with their pants pulled around their ankles, just giving it to them under oath, and especially whereby doing so another person is put in jeopardy of paying for a crime he did not commit. Perhaps a compromise is to create sentencing guidelines for perjury, just as there are sentencing guidelines for other crimes, and adjust the punishment to fit the injury to others intended by the perjury. You know what? If we just put everybody who lied under oath, who was an agent in agency in Guantanamo Bay for the rest of their life, they'd all shape up and ship out real quick, wouldn't they? So, a man who lies about his neighbor to extract a small sum of money is in small claims court might receive mild sentence, with one who intentionally misrepresents facts to cause another to pay for a crime of great consequence should be required to pay a greater debt to society. Keep in mind that perjury is a crime against the people who provide courts to dispense justice. Where perjury threatens the welfare of another, it is clearly a crime against that other person. But first, it is a crime against all of us, because it is the highest form of disrespect for those who sacrifice to provide courts of justice where the truth should be honored. We who try to uphold justice should not allow others to disregard this sacred oath with impunity, for our security and the security of our children depends on our continuing to work together to provide courts to redress the people's grievances by enforcing the truth according to the law. Oppose perjury. Conclusion. There is such thing as self-evident truth, contrary to the popular philosophies of the day. Truth does exist. Some truths are self-evident. Truths exist outside you and me, or our private perceptions of the universe around us. Truths are true, whether we wish to admit them as true or not. Truth does not depend on our opinions or the opinions of any multitude of authorities. That's what's real. That's what real truth is. That's the kind of truth this nation was built upon. For the good of all mankind, truth is not imaginary substance. Only irrational person believe otherwise. The self-evident truth expressed by the maxims of common law are true today. They were true yesterday, they were true at the beginning of time, and will undoubtedly be true tomorrow and forevermore. They are self-evidently true and accepted as such by all reasonable persons. men and women. The maxims of common law have been published in old law books for centuries, yet they are no longer taught today. Law school ignore them. Religious organizations are more interested in spiritual teachings about life after death and angels. Our public schools should be teaching the maxims, but they are not. So we live in an age of legal ignorance that could so easily be uplifted by the simple truths contained within these memorable sayings that guided our forefathers to build a nation predicated on their common sense principles of fairness and justice for one and all alike. Our Declaration of Independence is dedicated to the truths we hold self-evident, and our Constitution would never have been born and could not have long survived without their guiding wisdom that continues to promise this nation will remain the greatest ever to appear on our tiny planet. Self-evident truths are an essential part of our jurisprudential heritage. They are the heart of equity, the hope of future generations. Secure liberty and justice for yourselves and your posterity by discovering and sharing self-evident truths of common law on which legitimate governments are built and by which corrupt governments will eternally be judged. The trust of keeping justice alive is in your hands and the hands of those to whom you entrust it. Promote public awareness of these self-evident truths by telling others that the maxims of common law should be upheld by all our leaders. This is the best way to promote truth and equity in our courts and in the world. Thanks for passing the word. Only the truth is true. Nothing else is. Thank you for joining me, and have a wonderful evening.